All right, let's dive into a really fascinating digital mystery that's unfolding in China. We're talking about information that was supposed to be public, that's now just vanishing. So what's really going on here? So here's the core of the puzzle. For years, China was actually getting more transparent, putting millions and millions of court rulings online for anyone to see. But then, suddenly, a complete U-turn. Government sites, commercial databases, they're all starting to pull down massive numbers of these public records.
And that right there is the million-dollar question we're going to try to answer. Why would you go to all the trouble of making something public for accountability, only to lock it back up again? Is this about the government tightening its grip? Or is it about something a lot closer to home, like your personal privacy?
To really get this, we've got to look where the action is happening, inside Chinese courtrooms. And you won't believe this, but the whole conflict is perfectly captured by two real-life cases with outcomes that could not be more different. Okay, put yourself in this situation for a second. Imagine some old legal dispute you were in, maybe something pretty minor, is now online. Anyone with an internet connection can just look it up. Then you find out a company is scraping that data to build a credit profile on you. You tell them to stop, to take it down. What do you think should happen? And this is where it gets wild. That exact scenario played out in two different cities with two totally opposite results. In the Yi case, the person objected, and the court said, "You're right." Boom, data gets deleted. But in the Liang case, same objection, but this time the court said, "Nope, sorry, it stays public." Okay, so how is that even possible? The facts of the cases were basically the same. How can one legal system spit out two completely different answers? Well, it's a huge red flag that the laws are confusing. And to figure out why, we actually have to step outside the world of law and into, believe it or not, cognitive science. Right, and this is the secret key that unlocks the entire mystery. We're going to borrow a really powerful idea from a brilliant psychologist named Daniel Kahneman, and it's all about something called thinking fast and slow. So first, you've got fast thinking, or System 1. This is your brain's autopilot mode, you know? It's your gut feeling, that snap judgment. It's super fast, takes basically zero effort. Like, you see a friend's face, you know who it is. 2 + 2? 4. You don't even have to think about it. That's all System 1. But then, there's slow thinking, System 2. And this is the complete opposite. This is the heavy lifting. It's when you have to actually stop and think, like when you're doing a tough puzzle or deciding on a big purchase. It's powerful, for sure. But man, it is lazy. Your brain avoids using it unless it absolutely has to. Okay, I know what you're thinking. Psychology? What does this have to do with Chinese law? Well, here's the amazing part. The argument here is that China's data laws are, kind of by accident, built on these two different ways of thinking. So check this out. China has two big data laws, a new one called the PILP and the older Civil Code. And the whole idea is that one law is designed for fast situations and the other is for slow ones. And this table just lays it all out perfectly. Think of the PIPL. That's your fast lane. It's got simple, clear-cut rules for the digital world. Once data is public under this law, it's public, no takebacks. But the Civil Code, that's the slow lane. It's for complicated situations where you need to weigh everything carefully. And here, yeah, you can object later and ask for your data to be taken down. So that's the whole ballgame right there. You got fast fair use that you can't undo and slow fair use that you can. And suddenly, those two contradictory court cases make a whole lot more sense, right? The judges weren't just looking at the problem differently. They were using two completely different legal toolkits. All right, so we've got this cool theory that explains everything. But how does it actually work in the real world? Like, if you're a judge or a company, how do you know which lane to pick? Fast or slow? Exactly. That's the key question. If you have two different tracks, how do you decide which one to get on? Well, it turns out there's a pretty straightforward test you can use to figure it out. It's called the purpose dichotomy. And here's a fun fact. They actually talked about putting this idea in the law when they were writing it, but it got cut at the last minute. Even so, a lot of experts say it's really the only logical way to make sense of all this.
And the test itself? Super simple. Just two questions. 1, why was this information made public in the first place? And 2, is the new way it's being used consistent with that original reason? If the answer is yes, you're in the fast lane. If it's a no, you gotta slow down and use the other system.
Okay, let's run our court records mystery through this test. Why were those documents made public? Well, for transparency and to help build China's social credit system. Now, is a company using them to create credit reports consistent with that original purpose? You bet it is. It lines up perfectly. So that's a fast, fair use case, no question. And there we have it. We're full circle. This completely explains the ruling in the Beijing case, the Lian case. The court saw that the new use matched the original purpose, put it in the fast lane, and said the individual's objection, which came later, couldn't override it. Mystery solved. So, great. We solved the puzzle. But what does this mean for the future of data, for all of us? Because this isn't just some weird legal quirk. This has massive implications for how we think about information in the digital age. I mean, just listen to this quote from the actual ruling in that case. The judge is basically saying, look, if you make something public but then say no one can use it, what was the point? You're completely gutting the whole idea of transparency and the public's right to know. And let's be clear, this isn't just a Chinese issue. This is a global fight. Everywhere, we've got this huge tug-of-war between the push for open data on one side and the demand for a right to be forgotten on the other. It's one of the biggest questions of our digital lives. So, if you're going to remember 3 things from all this, make it these. First, sometimes the answer to a tough legal problem isn't in a law book. It's in how our brains are wired. Second, this battle between transparency and privacy, it is not going anywhere. And third, and this is maybe the big one, the lines between public and private aren't fixed. We are literally making up the rules as we go. Which leaves all of us with one last giant question to chew on. Just because a piece of information is made public today, should it stay public forever? Should public data, like an old court record, come with the best buy date? Think about it. Because how we answer that is going to shape the world we live in.